domain over the process of election. There is a provision in the Constitution, Article 2183, which says that it is the Election Commission who has been vested with the duty and prerogative to conduct general elections or by-elections in the country, and to ensure that elections are conducted impartially, fairly, transparently, justly, and all corrupt practices are guarded with. That provision has also been interpreted by the courts in many cases, and every time it has been resolved that it is the Election Commission which in its best judgment shall ensure that elections in the country are conducted in a fair, free, transparent manner. So the controversy started from the point when the Election Commission sought date for appointment of elections. There is confusion that in case the Assembly is dissolved upon the advice of the Prime Minister, who shall appoint the date, because Governor, if it is not instrumental in the dissolution, like in the Punjab, the Assembly was dissolved on the advice of Chief Minister of Punjab. The relevant article says that upon the advice, the Governor shall dissolve the Assembly, and if he fails or if he considers not to dissolve or if he is inactive, then after the lapse of 48 hours, Assembly would be deemed to be dissolved. So this is the point of controversy from where this entire the litigation Pandora was open. The Governor Punjab did not acted upon the device, and the Assembly was dissolved as per the afflux of time, like on the passage of 48 hours. So the first round of litigation was regarding the fixing of date, that who to fix the date. The matter was brought before Lahore High Court. Lahore High Court, after hearing the parties, directed the Election Commission to appoint a date after consultation. And the Governor filed an appeal in the Lahore High Court, which was pending. In KP, the Governor was in process of consultation and a writ petition was also pending in KP. When a two-member bench of Supreme Court of Pakistan, if you may recall, while hearing a petition regarding the removal or the transfer of a police officer, they took it so seriously and they considered that elections shall be held in a stipulated period, which is 90 days, and the time was passing through. So that the bench headed by Justice Ijazul Hasan, flanked by Justice Mazahir Naqvi, referred the matter to the Chief Justice of Pakistan to examine it and, if appropriate, take suo motu notice by constituting a bench. Pursuant thereto, a 9-member bench was constituted by the Chief Justice of Pakistan, which assumed hearing. In the initial hearings, 2 honorable members passed judicial orders. They recorded their separate opinions, and they said that since the matters are pending before the High Courts, and since 184.3, constitutional provision 184.3, which vests jurisdiction in the Supreme Court to take suo motu notices or exercise its own constitutional jurisdiction, is a concurrent jurisdiction with the High Courts. So the case was not found to be fit for exercise of that jurisdiction, and it was found appropriate, if the High Courts seized with the matter already, may continue with the proceedings. They recorded their separate opinions. In the meanwhile, the bench was reconstituted by the Honorable Chief Justice, because meanwhile an application was filed by political parties requesting that 2 honorable judges had already expressed their opinions, and there were certain other backgrounds regarding their conduct as judges. So they may recuse themselves from the proceedings, which is not something which is happening first time, I would say. We have experienced so many occasions where the remaining judges, which are 6 in number of the Supreme Court, who were not part of that 9-member bench, the bench may be constituted and the matter may be referred to them to settle this controversy. This request was also not acknowledged and turned down by the 3-member bench. The other, of course, was the presence of the judgment handed down by senior plenary judge, which directed office that cases involving question of under 184.3 may not be listed for hearing, and question was raised that in order to overturn that judgment, a judicial process has to be evolved, that a larger bench be constituted or matter be referred back to that bench for final adjudication, and it was not a matter to be dealt with by a executive circular. The honorable bench, the three-member bench headed by Chief Justice, overruled all these demands or objections or requests, and finally passed an order whereby they themselves issued a schedule fixing 14th of May as the date for polling, and the different stages of election were also elaborated, and directed federal government to provide funds and security, which were actually earlier refused on multiple grounds, and Election Commission was satisfied with those grounds after examining the same, that the conditions were not conducive for conduct of election for multiple reasons, primarily the security, ongoing security threats and situation, and the incidents being taking place in KP and Punjab different occasions. Moreover, in the current financial budget, the allocation of funds was not made, and having considering the economic conditions of the country, time and again elections and spending huge amounts were whether advisable or not advisable. This was also Election Commission. So they, in their own wisdom, they posted the date of election for 8th of October. The Honorable Supreme Court finally passed an order directing that no, this is no justification, the election be held on such and such dates. The government of Pakistan also took up this matter. The cabinet sought views of the legal experts during the meeting, the lawyers who were representing the political parties, and the principal law officer, the Attorney General for Pakistan. And the cabinet also resolved that it is a serious constitutional question regarding the original judgment which was handed down by 4 honorable judges rejecting the petitions. And minority view should not be implemented or imposed upon the authorities. And it would be in fitness of things that if at even that stage the court considers for referring the matter to a full court, barring those 2 judges who have already recused themselves. The matter was also discussed at length at the floor of the parliament, which is the proper forum to discuss important national questions, including any legal issues being faced by the nation or by the government, or having strong nexus with the national affairs. And the National Assembly also passed a resolution in the meanwhile requesting the Supreme Court of Pakistan to consider under the law the propriety principle, the procedures, as well as the good practices, and to ensure transparency and independence, that the matter may be taken up in the full court. That resolution has also not been given any weightage by the court anyway. So faced with the situation, the matter is now under discussion in the parliament. To great extent, it's being discussed here and there. That's why I find it appropriate to come to you, answer your questions, if any. I just opened up the topic with basic history and details. So any question?
This is lastly from CNN. I just want to know that, as we know, we have gone through the proceedings and your wonderful presentation today, briefing today. When we see the Constitution, there is no constitutional solution. Within the framework of Constitution, there is no solution. Then there is only one way left. And you can't invoke emergency according to Article 232 because the President is there. One of your colleagues has attempted to give a solution which is yet a controversial solution, that government is thinking to file a reference against the 3 judges. So how serious this move is? Rana Sanaullah has said in one of his interviews that they are thinking to file
it may be under consideration, but there is no decision as yet. And I think that it may or it may not be an option for that. It has to be thoroughly examined and pondered upon before making any such decision. And that decision, of course, is to be made by the federal government, which is the federal cabinet. But so far, there is no such serious move, with all fairness, I would say. However, as you suggested, there is no solution. No, there is a solution in the Constitution. Article 254 of the Constitution provides in unequivocal terms that if Constitution provides an act or a thing to be done within a stipulated period, and if that exercise or thing has not been done in that specified period, it would not be unconstitutional only for the reason that the same was not carried out in that stipulated period. Now, coming back to the instant issue that the elections are to be held in 90 days or not, the 90 days upper capping started, the period starts from 12th of January, which is actually the 90 days are being exhausted on 12th of April, which is around the corner. And in any way, case, the election have already been ordered, whether that order is purely constitutional or legal, or whether it is executable or not, because of the controversy which is yet to be determined, whether it is 4-3 decision or it is a 5-3 or 3-member decision. So in the presence of 254 in previous events at previous occasions, in 1988, the assemblies were dissolved the last week of May. I think it was 29th May, if I'm not wrong, by then President Ziaul Haq under 58(2)(b. 1988, when the Junejo government was actually dissolved by the President exercising its powers under 58(2)(b) of the Constitution. Now, the elections were to be held within a period of 90 days. So the May, June, July, August. But the polls were conducted in November 16th, November, the exact date I recall was either 15th or 16th of November. So at that time, a presidential reference was also sent to Supreme Court of Pakistan, because there were some issues regarding the expenditures, because in the meanwhile, no budget could have been passed by the Assembly. And the Supreme Court of Pakistan, invoking Article 254, allowed the expenditure as well as also indemnified the period which was consumed in conducting the elections, almost 5.5 months. Even in recent past, in year 2007, the assemblies, the National Assembly and provincial assemblies were to retire somewhere in the middle of November as well. So the Khyber Pakhtunkhwa Assembly, which was NWFP Assembly at that time, was dissolved in first week of October. And the rest of the assemblies, they completed their tenure in middle of November. So elections were to be held somewhere on or before 15th of January. In the meanwhile, Mohtarama Benazir Bhutto Shaheed, she was assassinated, and the law and order situation in the country was not so well and stable to go for elections. So Election Commission postponed the election without intervention of any court, exercising its powers vested in it under Article 218, read with Section 8 and Section 58, 7, 59 of the Act of today. Us waqt usme 103 of the ropa tha. So elections were finally, I believe, held at the end of the February. And now you recall the KP Assembly was dissolved in first week of October. So their caretaker setup remained there for a period of 5 or more months. So it's not the first time, and that's why the Constitution provides a provision which covers these kind of situations and remedy the delays. Moreover, it is the Election Commission, to my understanding, which is the body under the Constitution to ensure that elections shall be conducted in a manner which is transparent, which is fair, which is just, which is independent, and where the corrupt practices are guarded. Pakistan, as I earlier said, has a unique scheme under Article 2 to 4 of the Constitution, which provides the appointment of caretakers through a consultative process, a very transparent process that leader of house, leader of opposition shall decide the name of the caretaker, head of the government in the meanwhile. If they don't agree, the committee consisting of 4 members from opposition, 4 members from Treasury benches, they will resolve the issue in 2 days, and if they fail, then the matter would be referred to Election Commission. This exercise was carried out in Punjab. There was no consensus. Matter ended up with the Election Commission with 5-0 unanimous decision. The caretaker chief minister was appointed. Likewise, unlike Punjab, in KB province, the outgoing leader of opposition and leader of house, they concurred on the name of Mr. E'ظم Khan, who is, and then the caretaker governments were lodged. My understanding is that if elections are conducted in piecemeal, that the elections in Punjab are conducted right now, and election in KP are conducted in somewhere in July or August, which is also, if we go by the judgment, it is also the violation of 90 days principle. Now, why court kept silent on it, and why court referred the matter to the appropriate high court, and why not Punjab? I mean, these are the questions which need to be answered by the court while sitting in the full bench. So then elections are to be held in KP in July, August. And finally, the National Assembly and 2 remaining assemblies of Sindh and Balochistan province are to retire or complete their tenure. I think it's the 12th of August. So then there would be elections before 12th of October. Or if in the meanwhile these assemblies are dissolved, then the 90 days period. So it's all mess, it's all confusion. We are also passing through very tough times. We are going through the economic crunch. The economy is at the worst right now for multiple reasons. The worldwide situation is also very alarming. Our security position is extremely worrisome. It's alarming in a way. There is a surge of terrorism in Balochistan and in KP. The entire army which actually performs static duty, you know, 2,047 troops have been requisitioned by Election Commission to conduct election in Punjab and KP. It is almost half of the army. Now, they refused on the ground what they